Good evening and welcome. I'm Professor Andrew Lynch, the Dean of UNSW Law and Justice. I begin tonight's event by acknowledging the traditional owners of the land on which the University of New South Wales and the Faculty of Law and Justice is located, the lands of the Bidjigal people of the Eora Nation. I pay my respects to their elders past and present, and I extend that respect to other Aboriginal and Torres Strait Islander people in the audience tonight. I also acknowledge the invitation of First Nations people to all Australians to walk with them towards the future offered by the Uluru Statement from the Heart, one of voice, treaty and truth. I'm pleased to welcome everybody to our fifth Mason Conversation, a series named in honour of Sir Anthony Mason, marking his outstanding generosity and contribution over many years to UNSW, including his time as Chancellor of the University, and of course in reflection of his distinguished career and influence in law in Australia and globally. The Mason Conversation is a unique event in our calendar in which we explore the life experiences of prominent public lawyers and intellectuals in Australia and hear their reflections on contemporary issues and public affairs with a particular focus on a life lived greatly in the law. Our guest tonight, the Honourable Murray Gleeson, obviously fits that bill. He also has several very relevant professional connections to Sir Anthony Mason. Most obviously, of course, was that both of them served in the highest office of Chief Justice of Australia. But much earlier, in the 1960s, Mr. Gleeson began his career at the Bar in New South Wales in the chambers of Sir Lawrence Street, and Sir Anthony was working in close proximity as a leading equity and commercial junior on the same floor. Mr. Gleeson pursued an illustrious career at the Bar and made silk in 1974. He was president of the New South Wales Bar Association in the mid-1980s and was appointed Chief Justice of the Supreme Court in 1988. After 10 years' service, Mr. Gleeson was appointed Chief Justice of the High Court of Australia, the only Chief Justice of a state court to have been appointed to that office, apart from Sir Samuel Griffin. Mr. Gleeson served a full decade to 2008 before reaching the constitutionally mandated age of retirement, but in the same year he was appointed a non-permanent judge of the Court of Final Appeal of Hong Kong, on which he continues to sit, providing another crossover with Sir Anthony, who was an inaugural non-permanent judge of the court until 2015. It's a great pleasure and honour to welcome Mr. Gleeson to tonight's Mason Conversation.
Thank you.
Unlike an address or a lecture, a conversation is a relaxed exchange between individuals, and my other introduction tonight is for my colleague, Professor Rosalind Dixon, the Director of the Gilbert Tobin Centre of Public Law. Ros is a graduate of UNSW and Harvard and a Fellow of the Australian Academies of Law and Arts and Social Sciences. Ros is the other crucial partner in the Mason Conversation you'll be listening to tonight. And on this occasion, she's particularly well qualified, having worked with our guest as his associate at the High Court. My thanks to her and her centre colleagues for the preparation of this special event. Thank you, Ros.
Well, thank you very much, Andrew, and for the faculty's support for this event, and particularly to our colleagues, Tomas Allenby and Danielle Peake, for the wonderful work they've done this evening. Like you, I want to acknowledge that I'm joining the conversation from Aboriginal land and pay respect to the Bidjigal people, who are the traditional owners of the land I'm coming from, and lend my voice, like yours, to calls for structural change to the Constitution, a topic that I hope we'll return to at the end of the conversation this evening. But most important, Chief Justice Murray, thank you so much for joining us here at UNSW Law this evening, and doing so in celebration of the idea of a life lived well in the law. That was the animating idea that drew George Williams, Sean Brennan, Andrew and others to come up with this idea, and to talk about your continuing life lived extremely well in the law. But the celebration is looking backwards, and the life shall continue. But let me also say that we look forward to sharing this recording with Sir Anthony, who told me he was very much looking forward to hearing your remarks. And, you know, I'm sure we're going to talk a bit about your overlap, but also your shared interest in and role on the Hong Kong Final Court of Appeal. So Obviously, you need no introduction, and Andrew has provided an ample one. But I want to start at the beginning to take us all the way back to the beginning of your life in country New South Wales in Wingham. And I wanted to ask you to talk a little bit about that and whether you think it was a formative experience for you in your later life and career. Because, of course, having people from regional and rural New South Wales is an important part of the diversity of our profession and our judiciary.
Well, I grew up in a country town that had a population of 3,000 people. It was about an 8-hour drive from Sydney. I went to the local convent school for my primary schooling, and then when I was 11, I went to boarding school in Sydney. So I didn't live full time in the town after about the age of 11. We didn't live on a farm. My father had a garage in the town. We had a lot of relatives in the area. My mother's family name was Burry, and there are a lot of her relatives with whom I had close contact, and I'm certain that that was a formative influence.
And when did you decide, Murray, that you didn't want to be a garage owner, but rather a lawyer? Do you remember the stage at which that thought formed in the young Gleeson?
I decided I wanted to be a lawyer in about 1957 or 1958, when I was into my university course. I was educated in my secondary education at a school that had a boarding school that had a number of old boys who were prominent lawyers. My schooling, while it emphasised giving people opportunities for their future life, was all done by people who were members of religious orders. I was never taught any subject until I reached university by anybody who wasn't a member of a religious order. They all happened to be people who had taken vows of poverty. So I was never taught any subject at school by anybody who owned anything or received any salary. While there was emphasis at school upon progress in later life, there was emphasis on other things as well. I don't think I left school intending to be a lawyer, although that was one of the possibilities. In those days, they used to have people called vocational guidance counsellors who came to schools. And the person who counselled me certainly suggested law as a possibility and made it clear that there were various other things that I was unlikely to be good at. But that was one of the possibilities, but not the only possibility when I left school.
Can you tell us what they ruled out for you?
Anything to do with manual skills, anything to do with technological or engineering skills, they said, forget it.
Well, they chose well. And when did the idea form that you might become a judge? Was that something that only occurred to you once you were a silk and a busy practitioner, or did you have intimations of that earlier in your career?
No, I never knew any judges before I started to practice law. I knew very few lawyers. I didn't come from a legal family. The only lawyer I knew before I started work at Murphy and Maloney as an article clerk was the family solicitor at Wingham, who in fact was the person who recommended me to Murphy and Maloney because they were his city agents. I don't think I contemplated becoming a judge until about the time I became one.
Well, you obviously, had a lot of encouragement, but weren't from the kind of network where that would have been something, that occurred to you until much later. But tell us about university, because you were at law school at Sydney Law School in the 1950s and early 60s. What was it like learning law at the time? I know there are a lot of our law students joining this conversation and interested to learn about your career. So cast us back to what was it like at the competition at the time you were at law school?
Well, I was at university on a Commonwealth scholarship, as were most of my contemporaries. So we didn't have to pay any fees or incur any liabilities. I did a 6-year course, 2 years arts and 4 years law. The first year law counted as third year arts. After the end of first year law, I became an articled law clerk at the firm of Murphy and Maloney, and so did most of my contemporaries. There were a few of them who became judges associates, but most of them were articled clerks. The law school in those days, it was Sydney University Law School, there was only one. By comparison with the modern circumstances, was small, in a sense, even intimate. There was a lot of interaction between the undergraduates and the teachers. Most of our teachers were practicing lawyers. There were full-time teachers as well. I was just past the time when there were a lot of returned service people in the law. Let me be more direct, servicemen. There weren't very many female law students in my time at the law school, but there were one or two very prominent ones.
Was Mary Gordon one of them, Tertius?
No, Mary wasn't.
She was later.
She was, yes. Well, not that much later, but yes, she was later.
Can you
Jane
recall
Matthews.
those? Jane Matthews was
I
one
at the law school, Jane Matthews, who died not long
recently.
ago,
Yeah.
and became a judge, was there. There were a number of others. I knew Bronwyn Bishop at the law school. But I was past the stage of the returned servicemen. As I say, mostly had Commonwealth scholarships. One big difference from the present time was that there was a big dropout rate after year one. That was because you really didn't have to get very good leaving certificate results to get into law school. By comparison with modern circumstances, where it's only the high achievers who seem to make it to law school. But a byproduct of that was that a lot of people didn't pass their first year law. So the class thinned out after that. I have 4 grandchildren who are undergraduates at university at the moment, and I'm very conscious of the difference between the opportunities for an undergraduate life that I had and the opportunities that people have had in the last 2 or 3 years as a result of the disruption from the pandemic.
Obviously, the opportunities to be in class, meet friends, is so different. Talking of classmates, you had a couple of notable classmates, one of whom, John Howard, went on to be Prime Minister and his government appointed you. Michael Kirby was another classmate who went on to be your colleague. Do you have any recollections of either of those, or Bronwyn Bishop for that matter, other people that we've come to know in public life from those days?
Yes, I mean, of course, I remember all these people well from the law school. John Howard wasn't an exact contemporary of mine. He's a year younger than I am.
He was using your notes, no doubt.
And he did the 5-year course. Michael Kirby was an exact contemporary of mine. I first met him when we were both in first year arts, and we went through our law course together. 2 other names that I would mention particularly, they're both dead now, but they were enormously talented individuals, and they became judges, were David Hodgson and Graham Hill. There were quite a few prominent people that I knew and met at the law school and maintained close contact with afterwards. I would say, for example, that a lot of the work that I got when I went to the bar came from people that I was at the law school with, or their associates in their own law firms. So the relatively small size and the opportunities for personal contact that existed at the Sydney Law School in those days were very important. Don't forget, of course, that the law school was downtown. It wasn't on campus at the university. It was in the legal precinct in Phillip Street, opposite Counsel's chambers and opposite the law courts. When I was an article clerk at Murphy and Maloney, I could walk to the law school in 5 minutes. It was where the major law firms had their offices. That contributed to the degree of interaction that went on between law students, law teachers, and practitioners.
Well, geography can be so important to these interactions, but you talked about the bar. You went to the bar in 1963. I'm going to jump over your time as an articled clerk. Tell us about the early days at the bar. What sort of practice did you have? And who were the sort of figures that you read with or looked up to as counsel in those early years?
Well, as you mentioned earlier, I read with Lawrence Street, who was a very prominent junior at the Equity and Commercial Bar, as was Anthony Mason. And to those two names, I'd add Bill Dean, who became a close personal friend and played a very large part in my career. Those three had enormous junior practices, and they were very good at introducing people like me to work, so that I was able to get into a lot of action from the earliest times I was at the bar. I wasn't married until 1965, so for a couple of years I didn't have any financial responsibilities, but then I never had any difficulty making as much money at the bar as I'd made, making more money at the bar than I'd made as a solicitor.
I think it's really interesting, to remember those early formative influences, but also the connections that you maintained with Justice Dean, and that, Sir Anthony worked with you and Justice Dean in ways that sort of carried over for decades in terms of, the interactions and dynamics within the court. When you were a barrister, either as a junior or later as a senior counsel, are there cases that you remember arguing where you have a particular pride in them or memory of them being distinctive either in their rewards or their challenges?
Well, I can remember the first criminal trial I ever conducted before a jury, which was after I'd been at the bar only a few weeks. In those days, they had a kind of legal aid scheme that was called doc briefs. The name was traced back to the days when barristers used to sit in court, barristers who had nothing to do, and a prisoner in the dock could identify a barrister. I'd say, I'd like that person to represent me. The bar had a system under which the bar would assign young barristers to the defence of somebody. After I'd been at the bar a few weeks, I was assigned to defend a man who had been a youngish man who had been accused of breaking, entering and stealing. There was no solicitor involved in the case in that system of doc briefs. It was just me and the client, and I had to go up and sit in a cell, a prison cell with him, and listen to his story. He had been accused of breaking, entering and stealing, I'm sure, because some police informer had identified him as the person who did it. But the police had no real evidence against him. The only evidence they had against him was an alleged verbal admission of guilt that he'd made to two police officers in circumstances where he had refused to sign a written confession. He also had a long criminal history, which made it rather improbable that he would be engaging in confessional statements. Anyway, I met him in the cells, and he told me that he denied the allegation. He denied having, he ridiculed the idea that he'd made an admission to the police. But then we had a little wrinkle when I said, well, what were you doing at the time this robbery occurred? And he said, he told me he was up at King's Cross with a woman he named, who was a notorious woman associated with drugs, and indeed a woman who had been identified in the place as being involved in witchcraft. So I thought that that was not a name to conjure with before a jury. So we talked about how we could deal with that situation. And ultimately, when it came to the trial, the prosecutor opened the case to the jury. It became apparent that he had no evidence other than the alleged admissions to the police, and the jury started to roll their eyes. And then the police officers tripped over one another in giving their evidence and gave different accounts of the circumstances in which the admissions were made. And then my client made an unsworn statement from the dock, which people accused of crimes could do in those days. And he did it very well. He said, I deny that I committed this burglary. And he said, I certainly deny that I made the admissions to the police, which had the ring of truth about it. And then he said, and at the time of this, I was in the company of a lady whose name I do not wish to bring into this court, which was true. And so he was acquitted. He didn't say thank you very much or goodbye. He just ran for it.
Well, no doubt one of your major criminal law forensic triumphs, because thereafter you went on to have a more commercially focused career, and I'm going to take us to that. But I see we have a number of colleagues and inheritors of your roles on the call. Chief Justice, including Gabby Bashir, who's the president of the Bar Association. No doubt she'll be interested to hear about your early criminal forensic triumphs. But
I know Gabriel's parents from way back.
Moving on to your appointment as Queen's Counsel in 1973. Obviously, you weren't doing doc briefs for those accused of breaking and entering. You had a very full commercial and tax practice. You did some public law appearances. I always remember when I worked for you, you used to remind me how superior tax was to constitutional law. But do you remember any particular cases that you enjoyed running or that were special argumentative triumphs during your period as a silk?
Yeah, but I think tax lawyers are a better class of person generally. But when I was a junior in 1971, I did 2 cases as junior counsel for the Commonwealth that I think had an important impact on what I did later. One is the concrete pipes case, and the other is the payroll tax case, both in 1971. They were cases that had major consequences for the extent of Commonwealth power. As a silk, yes, I did plenty of cases that I remember. I actually I think that the people for whom I did the private law cases would be happy for me not to go into those. But the 2 most memorable cases I did as a silk were the hematite petroleum case, which was a case about duties of excise. The Victorian government imposed a tax upon the operations of SO and BHP in the Bass Strait, and the question whether that tax was invalid, because the Constitution says that the Commonwealth Parliament alone has power to impose duties of excise. That was memorable because of, amongst other things, the extremely vigorous response that I got from the then Chief Justice, Sir Harry Gibbs, who was a man inclined to be protective of the interests of states. And when he saw me coming with this argument against state power, he responded quickly and vigorously, but I thought I had the numbers, and it turned out I did. The other memorable case was the last appeal that ever went from the High Court to the Privy Council. That was a contract law case of Salmond and Spragan, and it only got to the Privy Council because it was so old. Appeals to the Privy Council had been abolished by then, but there was a grandfather clause. And I didn't appear in the case in the High Court. After the people for whom I later acted lost the case, I was briefed to advise on whether an appeal would succeed to the Privy Council. I said that I thought their real problem would be getting leave to appeal to the Privy Council. If they got leave to appeal, I thought they could win. They had a dissenting judgment of Sir Garfield Barwick in their favour. And the High Court had refused to follow or declined to follow a decision of the Privy Council. So I thought that if I could get the case to the Privy Council, then it would be fairly plain sailing from there, as it turned out to be. But the hard part was getting special leave. And that was a very tough contest, but that was what made the case memorable. The problem of getting special leave, and then the way it opened up after that.
And Murray, Sir Anthony is on record of saying that one of the things that caused a shift in his own jurisprudence in the 1980s was the final, abolition of appeals to the Privy Council by virtue of the Australia Act. Did you perceive a difference in terms of argument? Did you see the kind of removal of appeals as marking a shift from the perspective of an advocate?
Appeals to the Privy Council were abolished by a lengthy and very messy process. I think I appeared in the Privy Council about 15 times. And the last, the case that you just mentioned wasn't the last one. And some appeals went direct from state courts to the Privy Council. Indeed, the first brief I ever had in the Privy Council was in 1968 in a case concerning the will of the late Edmund Resch, who left a very large estate, and there was a dispute about the validity of a gift he made to St Vincent's Private Hospital. But that appeal went direct from Justice Jacobs in the Equity Division of the Supreme Court of New South Wales to the Privy Council. The reason the parties who were entitled to do so went straight to the Privy Council was that the people on the losing side had a decision of the High Court against them. So they wanted to bypass the High Court. And I was in a couple of other cases that went to the Privy Council because people were deliberately bypassing the High Court. Now, the first area in which appeals from the High Court to the Privy Council stopped was in tax cases. And that was while Sir Garfield Barwick was still the Chief Justice. And that made a big practical difference to what I might call the tax jurisprudence of the High Court. There was a case in the Privy Council that Sir Garfield Barwick had lost as counsel, and that didn't survive very well after the abolition of appeals from the High Court to the Privy Council. I think that as the High Court became the final court of appeal in the Australian legal system, there was a marked effect on the expectations of advocacy and upon the judgments of the High Court, in that they, to put it bluntly, the High Court became much more independent of English jurisprudence. And in respect of Australian constitutional matters or public law matters, that was very important. I am sure that over generations, members of the High Court chafed under the control that came from the Privy Council.
You talk about constitutional matters, and your earlier reference to your appearance in the concrete pipes and the payroll tax case brings to mind a comment that you've made to me in the past about the fact that you've been involved in matters of constitutional significance that would no doubt have been noticed by the Commonwealth as defending a relatively broad conception of Commonwealth power. Do you think that those sorts of considerations were a factor for those making appointments of members of the High Court, looking at their record on Commonwealth power?
I think I remember you once saying to me that I seem to have been socialised by the Commonwealth interests. I did appear for state governments too. I think that people get a certain appreciation of what in racing circles would be described as your form. That just means they know the way you think about things. I think also what is important is that they know you can see where they're coming from. That doesn't mean that you always agree with them. Take Sir Anthony Mason, who was Solicitor General for the Commonwealth, for example, an extremely successful Solicitor General for the Commonwealth for many years. When an Attorney General from the Commonwealth, is thinking of appointing somebody to the High Court, he he doesn't have a high degree of uncertainty about the legal experience of the Solicitor General.
And that would have no doubt been the case in relation to a number of other appointments subsequently, including Justice Gageler. If I may move on, Murray, to talk about your role as Chief Justice, I'll come back to some of these other themes. You're obviously Chief Justice first of New South Wales and then of the High Court. And, you know, the role of Chief Justice is a multifaceted one, and every Chief Justice brings their own approach. Did you have a conception of how you wanted to approach the role and how you saw your style as a Chief Justice?
I certainly didn't sit down and work one out for myself. I think the demands on the Chief Justice of New South Wales are different in a number of respects from those on the Chief Justice of the High Court. The High Court is a very small court. It must be one of the smallest courts in Australia. The Supreme Court of New South Wales has about 50 members. And of course, the Chief Justice of New South Wales also has functions and responsibilities in relation to the other courts in the New South Wales system. The Chief Justice of New South Wales is responsible for the administration of the court. On the other hand, in the High Court, it's the justices collectively who administer the court. So in one respect, the Chief Justice has decision-making power. The Chief Justice of New South Wales has administrative decision-making powers and authority that are more extensive. There's really nothing that the Chief Justice of New South Wales has to decide that requires anybody else's agreement. On the other hand, one of the things that I did, and I did this at the recommendation of Sir John Kerr, who had been a previous Chief Justice, was that I formed a committee of some of the most senior judges of the court, which was called a Policy and Planning Committee. And that committee met every month to consider the sort of matters about which the Chief Justice ultimately had to make decisions. And Sir John Kerr said to me, if you get these people to form a committee of that kind, they're going to be committed to your decisions when you ultimately make them. So it's a good way of, first of all, getting the benefit of their advice and their experience, and second, of binding them to the decisions that you're going to make on their advice.
And of course, on the High Court, that committee already existed, which was all 7 judges. And so it was a quite different context in which to be making those decisions. In terms of your legacies as Chief Justice of the High Court, one of the things I would note is that you introduced for the first time a media officer to speak to journalists and communicate a message about a decision that did not have precedential force, but which was approved by you or your colleagues as an accurate summary of the decision.
Well, that came from my time on the Supreme Court. None of these courts had that kind of officer until after I'd been on the Supreme Court about 2 or 3 years. That is, I decided with the Policy and Planning Committee that I've talked about, that the Supreme Court of New South Wales should have a public information officer. And we got a fantastic public information officer. I don't know did you know Jan Nelson? She died a year or 2 after I went to the High Court, unfortunately, but she did a wonderful job. She was a journalist. She was married, as it happens, to the president of the Law Society. Hilariously, somebody said, when we were in the process of selecting her, that we couldn't appoint her because her husband was the president of the Law Society. Well, that struck me as extremely odd indeed. I mean, it was a pretty touchy thing in the first place to start saying you can't employ a woman because of her husband's occupation. But if he'd been the head of the mafia or something like that, it might have been a consideration. But the fact that he was the president of the Law Society, I would have thought was an attribute.
Advantage, potentially.
Well, it produced this practical consequence that Jan was personally friendly with a couple of the judges on the Supreme Court that you wouldn't have wanted offside when you're fulfilling a role like that. Anyway, she was excellent, and it was because of the success of Jan as Public Information Officer of the Supreme Court that when I went to the High Court, I proposed to them that we have a similar office there.
There might be times where it's very difficult for that person to comment on everything that a court needs to comment on. And of course, one of the periods during your time as Chief Justice involved quite sensitive issues and controversies. Do you have a view about when it's appropriate for the court or the Chief Justice to speak publicly as opposed to the information officer? Is there a time and a place for the Chief Justice or the court to defend itself beyond the pages of the CLRs or what is said by the media officer?
I don't think there's a general rule that applies to that. I think you just have to handle it on a case-by-case basis. I'm trying to think of an example. Well, yes, I'll give you an excellent example from my time on the Supreme Court. Unfortunately, there was a former judge of the court who took his own life in circumstances of a lot of controversy and publicity. And as Public Information Officer, Jan Nelson not only dealt with the journalists who respected and trusted her, but also the family whose interests had to be considered. That was a situation in which I don't think I, as Chief Justice, could have said anything appropriately. But she handled that very well, tactfully, sensitively. Of course, if you're going to leave it to a court officer to deal, for example, with the media in relation to issues of the kind that have arisen, you need somebody in whom the media will have confidence. Apart from that, I think you just have to look at the issues as they develop on a case-by-case basis. It's difficult to plan for some kinds of contingency.
Sounds like a pretty fair summary of your jurisprudential philosophy more generally. I want to turn to jurisprudence and some of your decisions. And of course, I could joke and say you'd like to talk about tax law, but the Mason conversation is really a celebration of Sir Anthony's legacy across the Australian legal system, but particularly in public law. So I want to draw your attention to a couple of your significant public law decisions to ask you a bit more about them. The work choices decision was obviously a very significant decision, a controversial one in some underlying political sense, but in legal terms, perhaps not surprising to see the court expanding the scope of the corporation's power in the way that it did. Do you think that when you look at across the trajectory of the 20th century and more recently, that there's a sort of inevitable expansion in Commonwealth power, of which work choices is simply one of the significant points along that inevitable continuum?
Well, I mentioned the payroll tax case earlier, and in the judgment of Sir Victor Windeyer in the payroll tax case, in one or two paragraphs, he summarised why there has been this expansion of Commonwealth power. First of all, as at 1901, the field wasn't divided between the Commonwealth and the states. The UK government had a very important role to play in the exercise of power affecting Australia. with the end of the British Empire in the middle of the century, and indeed with World War I and after that during the 20th century, the power of the British government in connection with Australian affairs waned. And as I put it somewhere else, as the tide of empire receded, most of the uncovered territory was then occupied by the Commonwealth. The work choices case really built on the concrete parts case. There were various possible approaches to the corporation's power. The concrete parts case established that the Commonwealth, in effect, had power to enact the Trade Practices Act, or a law like the Trade Practices Act. I still have difficulty understanding how, if you took a narrower approach to the meaning of the corporation's power, you could sustain the trade practices legislation. And when you came to the work choices case, that concrete parts case approach to the corporation's power, I think, worked itself out. Just coming back to the payroll tax case for a moment, which was in 1971, when I was a junior on the side of the Commonwealth, there was something very amusing happened in that case that you won't find referred to in any of the law reports. Victoria was the plaintiff in that case, Victoria against the Commonwealth. And Victoria was formally represented by the Solicitor General of Victoria, although a prominent Victorian advocate, Keith Aiken, who later went to the High Court, did most of their argument. But when the Attorney General for Victoria got up to announce his appearance, he said, "I appear for the sovereign state of Victoria." And the Chief Justice Bowick said, "The what?" And he repeated that. And that, I think, is why in that judgment of Sir Victor Windeyer in the payroll tax case, you'll find a couple of paragraphs devoted to the question of sovereignty. He said, prior to 1901, the colonies, the British colonies in Australia were certainly not sovereign. The expression a sovereign colony, I would have thought, was a contradiction in terms. And he said in 1901, they became constituent parts as states of the Federation. They didn't gain any power then, and they lost some. So I don't think after that occasion, certainly while I was on the High Court, I don't think anybody used the expression sovereign state, although it's one you hear in American movies in relation to things like the sovereign state of Texas.
Well, we don't extract that part of the payroll tax for our students, but perhaps now we should, and give them the full context for Justice Windeyer's dressing down of the Solicitor General for Victoria. I want to talk about federalism in the context of COVID, and obviously this is just a question of armchair speculation for both of us, but obviously there has been a revitalisation of the role of the states and an interest in state government, in part due to the very significant role they have played in responding to the COVID-19 pandemic. Would you predict that that recalibration in federalism will play out jurisprudentially, or that it will only have a sort of informal political constitutional set of consequences?
I think the latter. Certainly Australians have been well and truly reminded in the last couple of years that they live in a federation. And let me give a practical example. There have been cases about the power of the Commonwealth under the defence power and the immigration power to make orders providing for control orders on the movement of people who are unlawful non-citizens, illegal immigrants, if you like. The control orders that have been made that have come before the court, and I'm thinking of a case of Thomas and Mowbray, contained very modest restrictions on people's movement compared to the restrictions on the movements of all Victorians or all people in New South Wales over the last couple of years. Indeed, the state governments not only exercised powers to require people to remain at home, they exercised powers to exclude people from their homes, which is a restriction of a quite different quality. So people have been reminded during the pandemic, first of all, that the fact that the Commonwealth has a power doesn't mean that the state doesn't have a power. It's only if there's inconsistency of legislation that becomes relevant. State governments have extensive powers to restrict and control the movements of people, as they restricted and controlled your movements and my movements over the last couple of years. And again, coming back to that case of Thomas and Mowbray, the restrictions exercised by state governments on the movements of people within their borders were done by executive regulation, not by judicial decision-making on a case-by-case basis. I don't know if you've read the book by Albert Camus called The Plague.
I'm familiar with it.
Well, you will remember that when the plague arrived in the North African town, the first thing that the authorities did was seal off the town and prevent people leaving or entering. The next day, there was a queue of people at the office of the mayor seeking exemption on grounds of personal hardship or some other grounds, so that they could be permitted to go or permitted to come. And the first thing the mayor had to do was to say, there will be no exemptions. This applies to everybody. The last thing that administrators want to do is deal with problems on a case-by-case basis. They want to have a general rule that applies to everybody, no exceptions. And that's the absolute opposite of the approach of the exercise of judicial power, which looks at all issues through the lens of the circumstances of a particular case and a particular individual. I would have thought that over the last 2 years, people, Australian people, have had a very good lesson in the extent of the capacity of state governments to exercise powers of control over the movements of people, and also of the exercise of powers of control over the movements of people by executive regulation, rather than judicial decision-making in respect of an individual case.
Well, you've just mentioned Thomas against Mowbray, and I think in many ways foreshadowed what might be the answer to this question, which is, I think your decision in that case, which was, of course, a decision about whether the making of control orders in respect of suspected terrorist offenders was compatible with Chapter 3 of the Constitution, you drew attention to the fact that allowing courts to play a role in supervising such orders was ultimately liberty enhancing and was not a role that should be removed lightly. Of course, the counterfactual argument is sometimes made that the involvement of courts adds a degree of perceived legitimacy to a particular regime in ways that further coercion and limitations on liberty. But you were very clear in Thomas in preferring the former view, and that same reasoning has been influential in some of your own judgments on the cable principle, but also other judgments picking up on your line of reasoning. So is it this case-by-case evaluation that gives you that confidence? Is it the independence of courts, all of the above, something else? What is it that underpinned your faith and conviction that promoting judicial involvement in relation to the supervision of such orders was in most cases likely to be liberty enhancing and to be preserved rather than prevented?
I think the reason for that is that you've got to consider what the alternative is. Now, in Thomas's case, the plaintiff in that case was alleged by the Commonwealth to have returned to Australia from an Al-Qaeda terrorist training camp. I don't know what the facts are, but that was the allegation that was made against him. You would have to be a fairly myopic person to think that if the Commonwealth didn't have power to pass a law controlling the movements of such a person in Australia, nobody would have the power to do it, or that if the control of movements of such a person were not exercised by the judicial process, in that case a federal magistrate, nobody would exercise the control. The alternative is to exercise it by executive regulation, by the administration. The most common form of order, judicial order, for the control of movement of an individual person, with which everybody is familiar, is an apprehended violence order. The apprehended violence orders weren't invented recently. They, as a matter of history, were in the line of orders made by justices of the peace to restrain apprehended breaches of the peace. Now, it's possible that if somebody returns to Australia from an Al-Qaeda terrorist training camp, somebody might take the view that he might possibly be tempted to commit a breach of the peace. And the kind of control and restriction orders that were made in that case were, first of all, they were very like the kind of condition that you'd see imposed on a bail order. The man in that case was restrained from leaving his home for a short period. This is intended to be an interim order, temporary order. He was restrained from leaving his home from midnight to 5 a.m. Now, maybe there are some people who want to leave home between midnight and 5 a.m., but compared to the restrictions that were imposed on everybody during the pandemic lockdowns, that was a pretty modest restraint. He was also restrained from, I think, buying weapons, and he had to report to the police 3 times a week, the sort of condition you'd see in a bail order. When apprehended violence orders are made by magistrates, by courts, they contain restrictions on people are often restricted from talking to members of their family, for example.
So Thomas and Mowbray has a lot of principle underlying, but it's not a decision that won you a lot of fans on the civil libertarian left. Conversely, Al-Kateb and your dissenting judgment in that case did win a lot of admiration from those who believe in common law principles and the defence of liberty.
It would be an interesting exercise to ask a member of the civil libertarian left of the kind that you refer to why he thinks it would be better that Mr. Thomas should have been dealt with by the Victorian government by executive or administrative order in the light of the experience of the last couple of years. Al-Kateb was, that was an awkward case because there was a gap in the legislation. And the question was whether the court would respond in its interpretation of the legislation, would respond to that gap by saying, well, it's covered by some general words, or, as I thought was the right approach, by saying if they didn't refer to it in their terms, they didn't deal with it. I think you would know this better than I do, but I think there was legislation following the decision in Al-Kateb that dealt with the position of stateless people. I may be wrong about that.
There was certainly executive policy that made some accommodation of it. And I think that the legislation may be, as you suggest, although I'd need to check. I want to move on to the common law principle on Hong Kong. But before I do, let me ask you a question you might not like to answer. That was a very finely balanced decision, 4-3. And as Chief Justice, you were in dissent on grounds that you and Justice Gummow were largely in agreement on, and obviously Justice Kirby had a different basis. Was that the kind of case, I'm not asking you to talk about the specifics, but the kind of case where, as Chief Justice, you thought it was appropriate to try and persuade colleagues to join you, or did you take a view that you were first among equals and it was for every judge to take?
I don't remember ever trying to persuade anybody of anything.
And of course, Justice McHugh has talked publicly about his own decision and his own thinking on that. So let's turn to Hong Kong. Obviously, the same sort of common law principles, the principle of legality, provide a very important bulwark. in Hong Kong, but as do a range of other rights provisions that were enacted, in Hong Kong after handover and in anticipation of it. In Hong Kong, of course, the challenge is quite distinctive. One has to draw on common law principles and commitments to liberty and balance them with a range of competing interests, some of them very sensitive. How do you think about achieving that balance in Hong Kong? Does it look different than the balance that might be struck if you were sitting in the High Court of Australia?
Unlike Australia, Hong Kong has a Bill of Rights, and some of the most important decisions of Sir Anthony Mason, while he was on the Hong Kong Court of Final Appeal, concerned that matter. I might say in relation to Sir Anthony Mason of the Hong Kong Court of Final Appeal that there has been no foreign non-permanent judge who has made anything like the contribution that he made to the jurisprudence of the court. And that is well and truly recognised to this day in Hong Kong. There's an article in the latest number of the Australian Law Journal that deals with the contribution of Australian judges to the Hong Kong Court of Final Appeal, written, I think, by a member of the Bar Association. But there's no doubt that of all the non-permanent foreign judges on the Hong Kong Court of Final Appeal, it's Sir Anthony Mason who has made the greatest contribution. He sat in his last case on that court at the age of 90 and contributed to many, many cases, including cases relating to their rights legislation in Hong Kong and the interpretation of their basic law. I think that the balance between common law principles and civil liberties that you'll find in the jurisprudence of the Hong Kong court is very much like the balance that you'll find in the jurisprudence of the High Court. But I would say this, and I want to emphasize this: the Hong Kong Court of Appeal, Court of Final Appeal, like the High Court of Australia, operates in public. And its decisions are all published, and the reasons for its decision are all very readily accessible. People who want to know what's going on in the Hong Kong Court of Final Appeal ought to read its judgments and indeed attend its hearings. I sat in the Hong Kong Court of Final Appeal twice within the last 6 weeks. On both occasions, I was doing it remotely from Sydney, but everybody else was masked in Hong Kong. People who are interested to know what's going on in that court ought to look at the work of the court. They ought to turn up and listen to the court proceedings and read its decisions and its reasons for judgment.
And Murray, obviously the one notable difference between Hong Kong and Australia in contemporary context is that the Hong Kong court now has something that looks a little bit like the Privy Council for Australia much earlier, which is it has a capacity to be overridden by a standing committee in Beijing. But that would be a familiar feature to you given your earlier practice experience of having the Privy Council in the background.
It's never arisen in any case in which I've been involved in on the Hong Kong Court of Final Appeal. In fact, I'm having some difficulty remembering when it last arose.
There are one or two cases where Sir Anthony sat in which it arose or could have arisen, but as you say, it's not a common occurrence.
It arose, my recollection, and Sir Anthony's will be better than mine on this, is that it arose in relation to cases in about 2005 or 2006.
On sovereign immunity.
Concerning, well, that was a question of immunity in relation to an arbitration award, as I recollect it, but the most touchy cases were concerning immigration and rights of permanent residents in Hong Kong. But that was many years before, for example, the national security law.
Was a different context.
Yeah.
So I note that one or two people have put things in the chat. I do invite you, if you're in the audience and would like to ask a question, that you could identify your question in the chat and whether you'd like me to read it for you or you'd like to be called on. And there will be an opportunity at the end to also put your hand up and ask, the Chief Justice a question. So one of the things that is, talking of touchy subjects, certainly one in which there's been disagreement, is whether continuing to serve on the Hong Kong Final Court of Appeal, all things considered, promotes judicial independence and the rule of law, or whether, as some judges have chosen to do, it is more appropriate, given the complexity of conditions there, to resign from the role of foreign non-permanent judge. You've made a very clear public statement about that in the past, but not everyone would be familiar with it. I wondered if you would reprise for us what you said in that statement and what underpinned it.
Certainly. I'd also like to deal with the question of numbers. A barrister told me at a function last week that he had been given the impression from things he'd read or heard in the media that there was some kind of mass exodus from the court. Nothing could be further from the truth. Let me deal with the matter of numbers. There are currently 10 foreign non-permanent judges of the Hong Kong Court of Final Appeal. At the beginning of this year, there were 12. 2 of them were also serving judges of the Supreme Court of the United Kingdom. Obviously there, by arrangement with the United Kingdom government, an arrangement that was made at the time of the handover in 1997. That arrangement came to an end when those 2 serving United Kingdom judges resigned from the court. The other former United Kingdom judges remained on the court. The Chief Justice of Canada, Chief Justice Beverley McLaughlin, remained on the court, and the 3 Australian non-permanent judges remained on the court. And the 3 of us, as a result of questions that we were asked by the media, made a statement to the effect that we didn't intend to resign from the court and that we supported the judges of the Hong Kong Court of Final Appeal in their commitment to independence.
So I want to ask you just 2 more questions before we open it up, Murray. One is about, being focused on the broader life, and the other is about some of your public statements. So as I said at the outset, and you corrected me rightly for using the past tense, the Mason conversation is a celebration of a life lived well in the law, or continuing to live well in the law. But one of the greatest tests of a life lived well, I think one could say, is as a parent, how one influences one's children. And as a parent, you and Robin must be extremely proud that all of your children, all 4 of them, have gone on to great professional and personal success, and you have wonderful grandchildren, but that your daughter is now a member of the High Court. And of course, you must be extremely proud of that. But I remember talking to you in various occasions about what her experience, Jacqueline's experience as a lawyer and practitioner, showed for you about the challenges for women in the profession. And I wonder, with her permission, of course, you might be willing to share any of those reflections on how her experience shaped your own thinking about the challenges of gender equality in the profession.
Well, of course, Robin and I were delighted and very proud of Jacqueline's appointment to the court. I don't actually see myself in some kind of patriarchal role. Jacqueline once said, when she was sworn in as a member of the federal court, that she became a judge as a result of a failure of, became a lawyer or barrister as a result of a failure of imagination. And I think that's a fairly accurate statement. I don't remember any agonizing on the part of anybody in our family about whether she would become a lawyer. She just became one. Everybody assumed that she would just do what I'd done. However, that did focus our attention on some of the issues confronting young women when they enter the legal profession, and this is a matter that you and I have discussed in the past, including when you were my associate. I think that Jacqueline's daughter Claire was born after she'd been at the bar a couple of years. I think that she had to deal with a problem that you've had to deal with too, and that is the question of how you relate family life with professional life. This is a subject that I'm sure that you know more about than I do. And you probably know better than I do what changes have happened in recent years. There were relatively few women barristers when I went to the bar. There were some notable ones. But the bar has tried to make itself more accessible to women, and I think it's very important for the long-term future of the bar that it should do so. I hear comments from people connected with the large law firms about the arrangements that they make for women coming into the profession, and about some of the difficulties in relation to hours of work, for example. You would have thought on the face of it that the bar ought to be a more attractive profession for women because of the flexibility of working arrangements and working hours. But I'm not sure how that works out in practice. I think that Jacqueline was fortunate in that she spent some years in the legal offices of, yes, public administration, which I guess, she's never actually told me this, but I guess is probably more welcoming or more convenient. But I still don't feel confident that I can understand the situation of a young woman with children practicing at the bar and how they handle that. Well, now you said that Gabriel Bashir was watching this, and I mentioned to you I've known her parents for 50 years, but she also would be an expert on this subject and know a lot more about it than me. But I think you and Gabriel have had to handle these problems and work out and Jacqueline and work out the solution.
I think there's no perfect solution, but we have made a lot of changes, and that you were involved in making some of those. And I think one of the things that is worth noting about Justice Gleeson, the current Justice Gleeson's career, is that it did have this somewhat zigzag quality to it, and yet has led to the ultimate judicial appointment. And I think it is an important example, as well as the way in which it influenced your thinking. And I know that you have been a very big supporter of a lot of women in the profession. And I always remember Commissioner Ruth McColl saying that, and I certainly was a beneficiary of it. But I think it is an important reminder that the challenges remain, as well as that we have made progress. I want to now turn to your post-judicial career, although I note that your career continues actively in Hong Kong, as well as in relation to arbitration and a range of other areas. But certainly in general, you've been relatively circumspect about making public statements. But one exception that you made was a speech you gave, I believe, at the invitation of Danny Gilbert, but you made public statements supporting constitutional change to entrench a First Nations voice to Parliament. And I suppose I wanted to ask you to talk a little bit about why you came out supporting that change, and also why you thought it was appropriate and useful for a former Chief Justice like yourself or Chief Justice French to make a public statement supporting that change.
Yes, I don't think it was an exception, because I had been asked to be a member of the Referendum Council by the then Prime Minister Malcolm Turnbull and the then Leader of the Opposition Bill Shorten, when the Referendum Council was established in 2015, and it gave its report on the 30th of June 2017. The Uluru Statement having been made in May 2017. And I was one of the council that recommended, that made a recommendation concerning the voice and the amendment of the Constitution. And what I was doing in that speech that I made in 2019 was giving my reasons for that. And they're there. I haven't changed my views about anything I said in that speech. Of course, things have moved on. There's been a lot of work done by other people and activity by other people, which I follow with interest. And I think it's fair to say that the matter has now moved into the political arena, which is where it ought to be. I have no objection to politics. I think politics is the way you get things done in a liberal democracy. And it's good to see the topic being debated and people opening up questions about it. One of the things that I said to other people on the Referendum Council, and that I think needs to be kept in mind about constitutional amendment, is this: we have a system of compulsory voting. At ordinary elections, I think a lot of voters rely on the party system to tell them how they're going to vote. I think it's different than a referendum about the Constitution. I don't think people can lean on the party. I'm in favour of the party system, by the way, and I'm in favour of compulsory voting, but I don't think that people can lean on the party system at a referendum in the same way as they do at an ordinary election. And that makes the politics of explaining a proposed change to the Constitution very sensitive. And I'm not an expert in that. The politicians are the experts in that. But an analogy that occurs to me is this: if you're a counsel addressing a jury of 12 people at a criminal trial, there'll be one or two people there who will want to follow every last detail of every piece of evidence. At the other extreme, there'll be one or two there who will decide the case on the broadest of impressions. And in between, there'll be a range of approaches. And the job of the advocate is to try and accommodate differences like that. And I'm very interested to see how the political experts are approaching the task of explanation and advocacy against the background of a situation where a lot of the people who are going to be compelled to vote on this are, at least at the moment, probably people who have only a very vague idea, if any idea, what it's all about.
And as you say, there's a lot of interesting work being done, including by colleagues of mine, Gabrielle Appleby, Megan Davis and others. Sean Brennan's on the call doing the work of not only the language, but some of the principles that will guide people as they look for some of those answers. I also wanted to acknowledge that you'll be interested, Murray, that a number of your successors, Chief Justice Bell is joining us, as well as Justice Leeming. And I wanted to thank a number of our advisory members, Justice Katzman, President Croucher and others, for being here this evening. Don't know if anyone would like to identify themselves by raising a virtual hand or writing a comment or a question in the chat, we'd be very happy to take a couple of questions before we finish.
That's good, Rosalind. You don't want to encourage people to.
Well, I'll ask you one question. Oh, we've got one. Brad, go ahead.
Can you hear me?
Yes, go ahead.
Chief Justice Gleeson, thank you so much for your time this afternoon. As a law student, I appreciate the work that you've done for the court's jurisprudence, and on behalf of law students, I thank you for being here. My question is in regards to, there have been calls recently that the High Court should expand its number of members to 9 members instead of 7. And I wanted to know what your thoughts were about that, if you think that the court in the future should expand to 9 members, or if you think the 7 members is adequate.
I've heard a similar argument in the United States, at the United States Supreme Court recently, but I didn't realise there was that proposal about the Australian High Court. I think my response is no. And the reason is this. I don't think that expanding the size of a court from 7 to 9 adds to clarity of the court's decision making. In fact, I'm not sure what I think would be achieved by doing that. I don't remember ever having to discuss that subject with politicians while I was on the court. I don't remember any Attorney General of either side of politics raising that possibility with me. There was a time, I must say, when I was at the law school, I think all the members of the High Court, except one, came from New South Wales. And when I was appointed to the High Court, there was a significant New South Wales majority. Now, that no longer applies. I wonder if part of this thinking is to get more people on the court from other places. I, of course, discussed appointments to the court with attorneys general over the years, and I was always struck by the fact that the issue of geography never seemed to be important. It's important in comments that I hear from people at the bar or in the media, but when it actually came to the making of decisions about appointments to the court, I don't remember geography playing an important part.
And of course, there is a discussion, arising very much, in general terms, but from the recent ALRC report about diversity generally on the bench. But of course, geographic diversity is one aspect of that, but a broader conversation about gender and cultural diversity tends to be the one that we focus on. We have time probably for one more or two more questions. It's lovely to have students joining if anyone else wants to ask a question. Mo, is there anything you'd do differently if you got to do it again?
Yes, yeah. But I've forgotten what they were.
Very diplomatic. We've got a question from Sanjay, who's one of my students, about diversity, which is noting that we've made some real progress in terms of gender diversity on the court, and of course Justice Jacqueline Gleeson's appointment is part of that. And there are some encouraging signs in terms of cultural diversity with the appointment of Justice Rangier, Justices Danji, Yahia and Chen recently to the Supreme Court of New South Wales, and full credit to them and their colleagues in relation to those appointments. But do you think there are barriers to people from culturally diverse backgrounds in reaching the highest echelons of the judiciary? And if so, is there anything we can do about it?
Do I think there are barriers?
Yes.
Yes, I do. Yes. Well, there's a language barrier to begin with, and facility with the language. I mean, there are. I mean, I don't remember when I was at the bar coming across a lot of barristers from what I might call diverse backgrounds. Some I remember, but I think the bar tended to be pretty monocultural. It's less. Look, I went to a dinner on Friday night of members of the floor that I used to belong to. I would say it looked a bit more diverse. It certainly looked a bit more diverse in gender terms than in the days when I was at the bar. I wouldn't have said it looked much more diverse in cultural terms, but I'm not sure I know. I would think that one obstacle that people from different cultural backgrounds might have is that they mightn't have the benefit of the same kind of personal contacts and associations as I formed.
And I think that those network effects, I mean, I think language is much less relevant when one talks about the kind of challenges we face today, where you have our best and brightest graduates often being from culturally diverse backgrounds. It's really much more about, is the bar seen as an attractive career path, and are those networks open? One of the things that I think is fair to say is that the solicitors, who are, in the profession tend to be much more diverse than the bar still, and the bar's doing really important work to address that. But would you see that as a reason to make appointments, among other things, gender and cultural diversity, to the bench directly from those practicing as solicitors?
I think it probably depends, amongst other things, about which part of the bench you're talking about. I get the impression from what I read that there's probably quite considerable diversity in the magistracy at the moment. I'm not certain about that, but I just get that impression. I'm not a fan of what I might call is positive discrimination still a...
It is a thing, and it's the term, but you're going to end on a low note if you start on that one, Chief Justice.
Well, I'm thinking of how you go about achieving diversity.
Well, we'll have to invite you back to the High Court of Australia class, which you've so generously appeared in numerous times, to educate you on that matter.
Of course, this is ultimately a problem for attorneys general. They're the ones who effectively make the appointments.
Indeed. So to end on a happy note, a question from Samantha Bottle. What advice would you give for law students in 2022? I know you have a granddaughter who's at law school, and no doubt you have advice for her as well as for Samantha. Do you have any general words of wisdom?
Yeah, try and get back on campus. I think that there's a form of discrimination for you. When you compare the advantages that I had during my time of going through law school, with the contact that I had with the other undergraduates and with the teaching staff and so forth, with the experience of my grandchildren who have spent at university and spent most of their time off campus, that's a very substantial form of discrimination in favour of me, but as against them. And I'd like to see that remedied as soon as possible.
Well, we can assure you, the Dean's working on it, our Vice-Chancellor's working on it, and so we are partners in that effort. We have now reached the end of our time. I did want to also acknowledge Justice John Baston, who is the chair of the Gilbert and Tobin Advisory Council, for being here, and acknowledge that while John has retired from full-time judicial duties, he is continuing to serve in that role and support the centre in so many different ways. Thank you, John. But the main thanks now is to you, Murray. Thank you so much for sitting down with me, for
You're welcome.
talking at length and with such candour, and to talk about topics both recent and, you know, very much going back to the early years, and for sharing your thoughts. I know that many people have enjoyed listening this evening, and many more will do so in the coming days and weeks. So thank you very much for paying tribute to the law school and Sir Anthony in that way, and to sharing such a rich career and set of insights with us. It's been a pleasure.
You're welcome. Good night.